SJC-10634 for office need.
Good morning, Ms. Robinson.
Good morning. May it please the Court, my name is Fran Robinson. I'm the attorney for the appellant Joseph Nee. With me at counsel table is trial counsel Thomas Drexler. Mr. Nee brings this appeal following his conviction for conspiracy to commit mass murder. He was acquitted on 2 other charges after a jury-waived trial in February of 2008. The charges stemmed from discussions that Nee had with 3 others, including Tobin Kearns, Daniel Farley, and Joseph Sullivan, about committing an atrocity at the Marshfield High School. In September of 2004, Nee gathered together Mr. Farley and Mr. Sullivan and went to the Marshfield police station after prearranging a meeting with the officer that was the liaison to the high school the day before. When they went to the police, they told of a plan that one of their friends, Tobin Kearns, had for putting off explosives, locking doors, and several other atrocities to be committed at the Marshfield High School.
Ms. Robinson, could I just ask you about that? Because there seems to be a disagreement between the 2 sides in the briefs. I read in your brief, but maybe incorrectly, that you suggested anyway that when Mr. Nee went to the police in September of 2004, he indicated that, yes, he was involved. The Commonwealth says very strongly that he did not, that he pointed, that what he did was point all his fingers at Mr. Kearns.
The exact testimony was from Officer Gray. She testified that he admitted that he was a follower in the plan, that the other 2 spoke in addition to him, but that he was the main talker.
When you say meaning that, because part of what got discussed was that there would be more than one person. Did he say, I was going to be one of those other people?
That's clearly what Officer Gray took it to mean.
I'm not. Can you actually cite to that testimony that Nee said, I was going to participate and I have decided not to participate?
That's part of the factual determination that we suggest a jury should have had to make.
No. This is a bench waive, Cloud. He exercised his right to waive the jury, correct?
The finder of fact. I'm sorry.
And we have the trial transcript.
Yes.
And to my knowledge, nobody testified that what Nee had said was, I was going to participate. I no longer want to participate. I will tell you everything that I can tell you in order to stop this conspiracy.
He testified in detail to plans that he had been present for.
No, I understand that.
And according to Officer Gray, her exact testimony was, and I think that's at the transcript at 146, I can correct that if I'm wrong, that he was a follower in the plan.
I have a question. Has any jurisdiction adopted the defenses of abandonment or renunciation except by statute?
Research has, I have not found any that have adopted the model penal code except by statute, but that is difficult to determine because where the defense is successful, it doesn't go on appeal and there is no written decision on it.
Well,
what's the majority?
Okay.
What's the majority of the state's position on this?
The majority of the states follow withdrawal and renunciation and abandonment.
In conspiracy cases?
Yes, Your Honor. And in addition, I'm sure Your Honor knows the federal authorities have always accepted a withdrawal defense. The defenses are limited. The defense that I come before you here today seeking for Mr. Nee's benefit is renunciation.
But since this crime, this particular crime, is completed upon the making of the agreement, what sense is there in allowing withdrawal or repentance as a defense? The crime is committed when the agreement is made.
The policy behind not allowing withdrawal, as I understand it from studying the case law, is that the crime is complete upon agreement. Therefore, if Mr. Nee, for example, riled up other people or encouraged them through his own participation in these talks to commit the crime of conspiracy, to join the conspiracy, then withdrawal would not remedy that. He would simply withdraw, as Timothy Corshane, who never got charged, did, and the conspiracy could go forward, having participated in encouraging it. Renunciation, however, is completely different. Renunciation requires him to thwart the criminal purpose of the conspiracy.
But it first of all requires him to say, I was going to participate. I don't, follower is ambiguous.
Your Honor, I would respectfully point to the model penal code that's reproduced at page 16.
No, I know,
by
but we don't
Henry.
have the model penal code.
Well, what we are asking you to consider is a defense of renunciation which does not require a full confession. It requires thwarting the criminal purpose under circumstances manifesting a complete and voluntary renunciation of his criminal purpose. So,
In the states that have adopted by statute,
yes,
do you know how many states there are?
yes, and they're all cited in my brief.
They're like half a dozen, as I recall.
Yes, Your Honor.
Do all of them use the model penal code definition of renunciation?
No, there are variations upon it. Some require, but none require a full confession. Some require that the actor come in sufficient time. Some require that the actor, that the manifestation of renunciation of criminal purpose shows an intent to thwart the object of the conspiracy. And some require that the actor actually inform all of the conspirators, the co-conspirators, that they're going to renounce.
It seems to me that the model penal code approach only makes sense if the state has a theory of conspiracy that involves an overt act in addition to the agreement. Massachusetts doesn't have that requirement. It's just an agreement. Once the agreement's made, once it's done, shouldn't that be the result here?
Well, again, I think that the refusal of Massachusetts to adopt the withdrawal defense is completely separate and distinct from a renunciation defense in that withdrawal doesn't help to stop the crime from occurring. Renunciation requires acts taken to stop the crime from occurring. And it's a unique and narrow defense. And in the context of almost tragedies such as this one, some terrorist activities that may be talked about in communities where people will know of it, I think it's a defense that should be seriously looked upon by this court.
So you're saying that essentially it's a reward for taking the extra step of going beyond the agreement and actually, well, you can only do it if some overt act is about to occur. Isn't that right?
You could do it at any time, but you must do it prior to the criminal purpose being accomplished. And you must do it in enough time to have a significant impact on stopping or thwarting the criminal purpose.
Well, what if all the people that are participants in the conspiracy, all the remaining people who are participants in the conspiracy, say, upon learning that the leader is going to pull out, what if they all say, well, in that case, we're not going to do it? Can the leader then renounce and go to the police and say, look, these guys had an agreement to do a certain act, I'm turning them in, and I would like some consideration with respect to a renunciation defense?
Well, I don't think that would be difficult for that individual to prove that they are doing it under circumstances manifesting a complete renunciation of criminal purpose. I think then, there would be certainly an argument by the Commonwealth, as they'll probably make here, that they went in for some other reason.
And isn't in the states that have adopted the model penal code approach, or isn't that part of it that it needs to? You can't have any ulterior motive.
Exactly. It has to occur with the purpose of stopping the crime from happening. It's simple and it's narrow.
But in this case, as I understand it, your client went to the police after Mr. Kearns had, I can't remember whether he'd been institutionalized or voluntarily committed to a mental institution?
Yes, Your Honor. That's factually true. His purpose in going in, though, as was demonstrated by the Commonwealth's own immunized witnesses, was that all three of these individuals testified that the reason they went into the police was because they were afraid that Tobin Kearns would actually do something, and that they had
How could he actually do something while he was incarcerated?
He was freed at that point, Your Honor. He had been released.
But I take it what they were, or no, I don't take. I will ask this question. The plan, as I understand it, was supposed to take place the following April,
Yes, Your Honor.
right? So we're sort of 6 months or 7 months actually in advance of that, correct?
Yes, Your Honor.
So what they were frightened of wasn't the plan per se, but more that he was acting strangely. He had asked for knives. It wasn't. Is that right?
Yes, Your Honor. He was actually, at that time, he was asking for weapons. He was asking my client to procure weapons. My client had just turned 18 and actually could have if he wanted to, but refused to. And the other two immunized witnesses also testified that they were really afraid that he was going to do something. And as the testimony evolved, at the exact same time that these three were sitting in the Marshfield Police Department, telling the Marshfield Police about the plan, someone was going on the computer at the Kearns household and looking up hundreds of images of different types of weapons, including tasers.
So if we agree that we should accept the renunciation defense, we'll call it, this would have to go back for a new trial. Because there was a fact issue, obviously, about whether there, in fact, would have been a renunciation.
Yes, Your Honor, because the trial judge who heard the facts made no finding.
Right.
He simply reflected that he felt that it was to a higher court to decide those things.
I'm having a little trouble understanding your argument that I think is, if this court says there is no renunciation defense, it shouldn't, that declaration should not be applied to this case. Why does that help you?
Well, in looking at the Klein case, which this court decided and actually adopted the model penal code self-defense for civilians, use of deadly force in self-defense for civilians, the court observed that it wasn't clear at the time that the actor in that case acted that he would not be justified in using deadly force to defend property.
That's a flip side kind of thing, right?
Yes, Your Honor.
But what conceivable basis did your client have to think that the renunciation defense was available to him?
Well, as we view the Nageli case and also United States versus Buttrick, it is not clear at all in the law as of 2005 that this defense was not available. I'm sorry, Your Honor.
Why?
Well, in Nageli, the court goes on to declare that withdrawal wasn't available to Nageli, and it clearly wasn't on that set of facts. And then in a footnote, the court goes on to say, even if the defense of renunciation were available, these facts do not support it. And so they're not saying that renunciation isn't available. They're not saying that it is available. It's just not clear whether it's available or not.
Has the legislature ever considered this?
This was part of, along with the McCool insanity instruction and the self-defense instruction that was adopted by this court in Klein, this was part of an omnibus crime package that was put to the legislature in proposed form in 1972, none of which was ever acted on. However, this court did adopt the model penal code in those two other instances.
Has Homeland Security, whatever that office is called, have they gone to the states who have not adopted the renunciation defense and said, look, this is really a great idea, you should do it?
I am unaware as to whether they have or they have not, Your Honor. In my view, and on behalf of Mr. Nee, I would say that this case does present the opportunity in those most scary of circumstances to allow people to come forward and thwart conspiracies which may be afoot. And that's what we seek to have you do.
Can I just ask you one question about your alternative argument? I take it that you say there was insufficient evidence of for Mr. Nee's participation in a conspiracy because why?
Insufficient evidence of intent to carry through. Each of the conspirators that came in testified, as did most of the civilian witnesses that overheard these admittedly unattractive ramblings. Each of them said, we never took this seriously. And then when the three, Nee, Farley, and Sullivan, go into the police, they say, the reason we're here is because we actually think Tobin Kearns is going to do something. In other words, they did talk. They did detailed talking, but the manifestation of an intent to carry through is not substituted for by overt acts. You can go down to Ferry Hill Thicket and try to set off a styrofoam bomb, which is, I would suggest, not uncommon among young people, and not intend to mass murder everybody at the high school.
And you need that intent in order for conspiracy?
Yes, Your Honor.
Thank you, Ms. Levinson.
Thank you very much.
Ms. O'Sullivan.
Good morning, Your Honors. Karen O'Sullivan for the Commonwealth. I would first like to address the issue as to whether or not the transcript indicated whether or not the defendant, whether there's any testimony that the defendant was involved in the conspiracy. And I would cite to the defendant's brief on page 24 when, in addressing the argument whether the evidence was sufficient against the defendant, he cites at transcript 1, pages 59 through 60, a direct quote from Officer Gray in which she stated, all three, meaning the defendant, Farley and Sullivan, all three never admitted to being involved, nor did they think that Toby was going to commit this plan into action until recently when Toby began acting strange. So I would suggest that that in order for there to even be a valid claim of renunciation, there has to be an acknowledgement that one was involved in the conspiracy, and that simply isn't the case here.
But when Ms. Robinson says that there was language about being a follower, is that what?
And a talker.
At the time that they went to the police, that is the only evidence that the defendant was being the talker. I would suggest the testimony from the witnesses, or strike that, I would suggest that in viewing the testimony, the defendant, when going to the police, in fact indicated that Tobin Kearns stated that 3 accomplices would be necessary to follow out this plan, and that at the end of this plan, Tobin Kearns would shoot 2 of his accomplices in the head and would bring 1 up to the roof with him. I would suggest that statement would suggest that certainly neither he nor Mr. Farley nor Mr. Sullivan were one of those 3 accomplices, knowing that 2 of the 3 would be killed before the end of the
But why isn't this failure to admit involvement, why isn't that consistent with the whole idea that they thought it was a joke?
Well, I would suggest that was a self-serving statement of the defendant to the police, but the evidence that was presented during the course of the trial was not that this was simply a joke. As I stated in my brief, the defendant approached several individuals, Farley, Sullivan, Corshane, and asked if they would be willing to assist in shooting up the school. And on several of these occasions, the defendant was with Tobin Kearns. The defendant made statements to several individuals that he had access to guns, that he had access to weapons. The defendant indicated to several witnesses that he knew how to build bombs, that he had experimented in building bombs. The defendant told witnesses that if anything were bad to happen, rest assured you would be safe, I could protect you. He indicated to witnesses that he had access to Tech-9s and things of that nature. So, again, the evidence presented at the trial was that the defendant was, in fact, a participant in this conspiracy, although the defendant never at any time acknowledged that when he went to the police. The position of the Commonwealth was that the defendant's relationship with Mr. Kearns had significantly deteriorated from the time of his hospitalization until September of 2004 when he went to the police. as stated in the brief, when he went to visit Mr. Kearns at the McLean Hospital, he had observed a change. He was upset that he was hospitalized. He thought that he was being brainwashed. And he even talked about breaking him out of the hospital. And upon Mr. Kearns' release from the hospital, his girlfriend observed a change in his behavior, a positive change in his behavior. And the defendant even acknowledged that in August of 2004, there was an encounter between he and Mr. Kearns, where Mr. Kearns pulled a knife on him and threatened both him and his family.
Well, is it your position, am I understanding this to be your position, that even had we had a renunciation defense, I know this was jury waived, but a jury instruction would not have been appropriate? There was insufficient evidence even to support an instruction on the defense?
Absolutely, because as the Model Penal Code states, there must, under the Model Penal Code, that it is an affirmative defense that the actor, after conspiring to commit a crime, thwarted the success of the conspiracy under circumstances manifesting a complete and voluntary renunciation of his criminal
And that wasn't an
purpose.
issue of fact for a jury to decide whether there had been a complete renunciation?
There was absolutely no evidence that when the defendant went to the police, he acknowledged in any way having been involved in this conspiracy. All he did was inculpate Tobin Kearns. He never at any time indicated that he, or Mr. Sullivan, or Mr. Farley were in any way involved in this conspiracy.
I take it your position is the following. In order for somebody to go to the police, they must have heard about the actions, correct? And one person goes to the police and says, you know, I've heard him, Kearns, talk about this. This is what he plans to do. This is what I've heard him say, so on and so forth. Another person says, Kearns and I were planning to do this. I'm coming to you because I don't want to do it, and I want to make sure that you stop him from doing it. You're saying, in this case, it was the former, I take it, if we look at the evidence.
Absolutely.
And that is not sufficient to warrant a renunciation defense.
Absolutely. And if you look at
Now, what do you say to Ms. Robinson's statement that the Model Penal Code does not require a, quote, full confession?
Oh, I dispute that. I would suggest that when the Model Penal Code states there must be a complete and voluntary renunciation, that there is renunciation posits prior participation, and one cannot renounce a conspiracy that he had never joined. And if you look to the cases cited, the jurisdiction cited by the defense in its brief, and I address in my brief, where the Model Penal Code has been adopted, or renunciation and abandonment is a defense to the crime of conspiracy, I would suggest that even if the defendant were entitled to those defenses in those jurisdictions, he still would not prevail. And I explain why in each of those jurisdictions, why he would not prevail.
Have the states which have adopted the Uniform Penal Code defense of renunciation uniformly taken the position that there must be a confession? Or at least an acknowledgement as a member of the conspiracy?
Yes.
I suppose by definition that's what renunciation is.
Yes.
And I think they all use, I don't know, but I'm relying on your beliefs that they all use the term complete renunciation.
Absolutely. And also it's very important to recognize that all of these states that have adopted the defense, it has been done by legislative enactment.
Yeah, if I could ask about that. In those states, is conspiracy a common law crime as it is here? I mean, in our statute, there are no elements for conspiracy. In the cases where the states have passed legislation, have they set forth the elements of conspiracy in their statute?
I cannot answer that question.
And I guess the next question is, jurisprudentially, is it your position that we can't add this affirmative defense?
Yes.
And because?
Because it would be a significant change to the law of conspiracy. And any fundamental change can only be done by way of legislative enactment.
But the problem, of course, is that here in our statute it just says conspiracy. Essentially the legislature has left it a common law crime and left it to the courts to ascertain what the elements are. Are you saying that we're frozen in time now, and the legislature having adopted it, we have to
I think,
That-
yes, I
that-
think
That they
this-
adopted the common law as of the time of that enactment?
I think that this court has an obligation to recognize what the legislator has enacted and to, I think, they would fundamentally change.
Well, we
the
change,
matter-
we change definitions of crimes regularly. I mean, we change the definition of felony murder to require felonies to be inherently dangerous, not just felonies that are, and that's because they're common law crimes. They don't need to be only a felony punishable by life imprisonment. They also have to be inherently dangerous. We added that in the mid-'80s.
But by adding that a defense to the crime of conspiracy, where the case law has been quite clear that it is not a defense, it would fundamentally change.
But that's what the common law does.
The case law stated in Commonwealth v. Dellinger, Commonwealth v. Nigeli, clearly address whether or not withdrawal and abandonment is a defense to the crime of conspiracy.
No.
That may be, but it's not, the legislature hasn't said anywhere explicitly that what the common law has defined as conspiracy to date, we are now adopting as a matter of statute.
Yeah.
They haven't done that.
Yeah, the legislature has not created the crime of conspiracy. They've created many crimes, but not conspiracy. As it appears in our statute, it's merely a codification of the common law.
Correct, but it is Commonwealth's position that any further fundamental change is a matter for the legislature and not for this court.
No, I know that's your position, but that's not consistent with what we've done. And in
again-
fact, one could argue one reason why the legislature does this is to permit the evolution of the common law, which includes certain changes. And of course, the legislature can always say, nope, we didn't like that one, and they frequently do. But that's the give and take between the legislature and the judicial branch.
It wouldn't be an evolution, it would be, again, a fundamental change, which, again,
Well, we can do that. We've done that.
and again, if you look to the other states that have, again, adopted the defense, it's all been done by legislative enactment and not by the courts.
Do you know if the crimes of conspiracy in those states have been legislatively defined?
That I cannot answer. That I do not know.
No, under federal law, you say there is a defense of renunciation?
Under federal law, yes.
And is that by statute, or has that been by the common law?
By statute,
The statute, which statute provides for that?
that I do not know.
Is that new?
Pardon?
Is that a relatively new?
I'm sorry, I can't answer that question.
Okay, so you don't know whether it's by common law or by
I
statute?
don't. What I do know is that in the Commonwealth of Massachusetts, the defense of withdrawal and renunciation is not a defense. And that has been made abundantly clear in the case law. In addressing the second issue raised by
Well,
the
you can
defense-
actually read that footnote. It's an appeals court decision. I know that. I say one could read that footnote.
Yes.
And it's an appeals court decision. I understand that to say, we're not saying it's not there. We're just saying we don't have to reach it in this case. Now, there are two ways to read that. One is, I regret that appellate courts sometimes do that, to say we're not going to reach that. But sometimes that's a signal from an appellate court that there might be some cases where this might be recognized. So if anything, that's Ms. Robinson's argument that even if we don't recognize that the defense of renunciation in this case, it should be made available to the defendant because the defendant acted, she argues, believing that his actions in this case would be a defense to a subsequent indictment for conspiracy by the Commonwealth.
In the sole case cited is Commonwealth versus Klein, and in that case, the defendant believed...
That's an appeals court case, right? Isn't that?
It's an SJC case, Your Honor.
Isn't it Agnelli or something? There's a little...
Nageli.
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 But in the Klein case, the court found that the defendant, at the time he committed the crime, reasonably believed that what he was doing was not a crime, and we don't have that in this case.
I get it, yeah.
So the withdrawal, as I state, came months after the crime was completed. So I would suggest that case is not applicable here. Addressing the sufficiency of the evidence, I would suggest that there was ample evidence for the judge in this case to find beyond a reasonable doubt the defendant had in fact entered into the conspiracy. I would suggest that although there was conflicting testimony amongst the witnesses presented by the Commonwealth, the judge certainly was in his right to accept all or none or in part the testimony, and just because there was some inconsistent testimony presented, that does not make the testimony inadmissible or unreliable. So I would suggest that under the proper Lattimore standard, the evidence presented in this case was sufficient. If there are no other questions?
Thank you, Mrs.
Rest my
Hunter.
brief. Thank you.